Good afternoon, everyone. My name is Don Duval. I'm the Vice President of Client Services here at MaRS. It's with great pleasure today that I introduce Victoria Heppel, hopefully I pronounced that last name correctly, from Gowlings. And as some of you may know, Gowlings is actually one of the legal partners of MaRS that offers pro bono services to our early stage science and technology companies to help address a whole entourage of legal related questions. So we appreciate your time here today. By virtue of background, Victoria joined Gowlings' Toronto office in 2005 and works in the Intellectual Property Group. She is a registered patent agent in Canada and the United States. Since 1999, Victoria has specialized in life sciences technologies, including the areas of chemical, pharmaceutical, and biotech. She has drafted and prosecuted patent applications before Canadian and US patent offices and has gained valuable experience in preparing opinions on patentability, infringement, validity, and freedom to operate. So with that experience, you are in for an exceptional presentation today, and I'm sure there'll be some Q&A at the end. And without any further ado, I'll turn it over to Victoria. Thank you.
Thank you. So we're going to be talking today a little bit about best practices for life science companies in the patent area, talking about sort of cost-effective strategies for looking at your IP portfolio and what you can sort of do when you're going along this road of spending money on patents and IP to try to maybe sort of make sure that you get value for the money that you're spending and something that's a tangible, good asset for the company and value. So an IP portfolio can actually be used in a variety of ways to provide an actual asset to a company. Particularly startup companies, this can be a valuable tool that you have in your pocket as you're looking to maybe go out and find investment from third parties. But to be able to use the actual IP portfolio, you can use it to carve out a niche for yourselves, to generate profit through royalties, through license agreements, and maybe to actually attract potential investors to your company as well. But in order to do this, you have to actually have strong patents and coverage for actually what you're doing, and sometimes also maybe keeping other people away from the niche area that you're working in. So what is intellectual property? What is an IP portfolio? It consists of several things: patents, trademarks, copyright, industrial designs, and trade secrets. In the life sciences area, you'll tend to find mostly that it's focused on patents and maybe trademarks if you're trademarking the company name, or if you're coming up with a new medical device or a tool, you've got a name for it, you may seek trademark protection for that. And industrial designs can also be applicable more in the medical device area when you have a new tool coming out, maybe it's a new pacemaker and it's a particular shape of the pacemaker that you're using, you may seek industrial design protection for that. But as I said, patents are sort of one of the main focus areas for a lot of life science companies and startups. So what does a patent do? It provides the right to exclude others from making, using, selling a product or a process during the lifetime of the patent. And in exchange for that, you have to have an enabling disclosure within the patent to allow somebody else to be able to do what the patent covers and the claims once the 20 years is finished after the rights to exclude them. The term of the issued patent is 20 years from the time of filing. And patent rights are territorial, so you always have to look at where you're going to be practicing your invention and maybe the end market. Other companies, jurisdictions, maybe where there are competitors, where you're going to be selling the product at the end of the day. And the one thing that you have always got to remember is that an issued patent does not necessarily grant you the right to practice your invention. So you may have a patent that's issued on a new compound or a new use of a compound, but there may be an earlier patent that has a broader scope. The actual compound maybe fell into, so maybe you can only seek rights to a new use for it, but you might still have to license back to actually the compound patent itself. So you always have to bear in mind that just because you have a patent on something doesn't necessarily mean that you do have the right to practice that invention. So why patent? Because they can generate value for your company, and they can do that in several ways. There's a competitive advantage to prevent other people from copying what you're doing, which can help you gain a market share. So if you're able to exclude other people and competitors, then you have that focus in the market. You can use patents as blocking patents to prevent other people from coming in, not only excluding people from exactly what you're doing, but maybe you have a broader scope of claims in your patents or in your portfolio that carve out a bigger niche around the area that you're working in to prevent competitors from coming into that market area. So you're not just covering what you're doing, be a bigger scope around the area that you're working in, so you're keeping competitors at bay and maybe they decide not to come into this sort of market area. You can generate income from royalty streams, so licensing patents, whether that's through an exclusive license or licensing to several people, and that brings in a royalty stream to your company. And of course you can attract investment from other people. If you have a good IP portfolio, a good way to cover your product and block others from what you're doing, other companies that are looking to invest, it's going to be a more attractive investment to make, knowing that other people can't come in and take a piece of the market share. And negotiating for possible cross-licensing. If you're working in a particularly crowded field, you might have a patent that issues on one aspect, and maybe a competitor has something that's quite close. And maybe you can use the patents that you have to arrange a cross-licensing agreement with somebody else, so you can both work in a specific field. So the value of an IP portfolio. Usually when you're a startup, specifically in the life sciences area, but it's across the board, you usually have a small niche in which you're focused and where you excel at a certain technology. Maybe this is in small molecules or maybe a medical device area. So you're wanting to look out to go to other investors perhaps to get more money, to have people have interest and invest into your company. So these strong patents can be this asset that allows the attraction of other people to come to invest in what you're doing. So it does form a large part of the value of the company. And a lot of investors will look to see, do you have a patent portfolio? Maybe it's not an established one because you're just an early stage startup, but have you actually filed for protection for what you're doing? And if you haven't, is there a reason for that? Are there other competitors out there that maybe are going to end up blocking what you're doing? And in that case, the investment in your company is maybe not as secure for them. So deciding what to patent. There is no way around it. Patents are an expensive process. From beginning at early stages to drafting patents, to going through the prosecution of patents, to filing in all the many countries and jurisdictions, it is expensive. And once you get out into filing into other countries, you're looking at filing fees, examination fees, sometimes translation fees. So you want to make sure that you're actually getting value for what you're doing. So you're filing in the right jurisdictions. And your initial filing is an actual worthwhile filing. So the value can depend on other factors beyond simply the technical merit of what's in the actual application. In the life science area, a lot of startup companies come from a basis of research, maybe to do it from a university or from an institution, maybe a medical institution, a hospital. And as we all know, in that sort of field and area, publications is a very important thing. Sometimes for tenureship, for getting funding from other people, getting grant money, it's important to have publications out there. The one thing that you do have to remember is just because something is interesting for a publication in the research field, it doesn't necessarily equate to A, being something that is patentable, or B, even if it is patentable, is it something that actually adds value to a company? Is it going to end up protecting a concrete product at the end of the day that you can use as an asset to bring in money into the company? So you always have to make sure that review, what you're doing on the research side, does it actually translate into valuable patents? And you always have to remember that. Is what you're doing so novel that broad claims are likely to issue? One of the things that you're wanting to always look at is the type of claims that you're going to end up getting in a patent application. If they're going to be quite narrow in nature and only cover what you're doing, but other people can work around them, it's not going to end up being that valuable to you. If you come out with a product and somebody else, a competitor, comes out with a similar product, your patent doesn't stop them from doing that, and now they're sharing the marketplace with you, and you're not getting as much profits. And as well, if an investor comes to look at that and sees that you're actually going to end up with quite narrow scope and maybe not get a sort of big piece of the market share when you come onto the marketplace with the product, it might not be as attractive as an investment for them. So along with that is, can you block others? Can you preclude others from copying what you're doing? So not only can you get protection for what you want to do, but can you expand that out to preclude others from coming in and from copying you or coming up with a similar product? And is it difficult for competitors to design around it? And part of that is looking at sort of your research side to see, how easy is it to work around what you're doing to come out with something that, again, they can come into the marketplace with. And then as you're looking to decide what to patent, you should also be looking at the types of claims that you're going for. Is your end product going to be something like a small molecule or a peptide or a polypeptide that you're going to be using as a therapeutic somewhere? The types of claims that you're going for can either be product claims, maybe they're method claims, maybe it's a synthesis method that's a novel method to use, or maybe it's a second use of a compound, a use claim, or in the United States, the method of medical treatment claim. Can infringement of such claims be easily detected? So if you do end up with a patent, is it actually going to be valuable? Can you actually go after people who are potentially infringing? If not, where is the value perhaps in actually having that patent out there? Maybe it'll deter people, maybe that's good, but if you can't actually go after people and prevent people from doing something, it's hard to detect, it might not actually add as much value to your company. So you should also look at the types of claims that you can get, not only how broad or narrow they are, but actually what type they are. So your filing strategy, when you start off down the road of looking at your IP, you have to think about not only what is the validity of all of these IP and the patents that you have and your scope of your claims, but you have to think of several things in coordination with that. Your business plan. What are you actually planning to do as a company? What is your end goal? What is your end product that you're trying to do? And do you have enough research to cover that end product? Sometimes obviously it's a long way down the road, so it's not always clear at the beginning. But where is your research going in line with your business plan? And at the time when you're looking to think about filing, do you have enough to actually cover that and to secure that as IP, as a patent? What's the end game? What's the vendable product going to be? And as I said, what type of claims are you going to have? Are they going to be narrower in nature and not provide as much protection for you, or are they going to be broader and not only allow you to have the market share, but keep others out? And your market analysis, what is your market going to be and where? Once you start going further down the line in the patent process of looking at different jurisdictions and filing abroad in other countries, where are your end markets going to be? If you're coming up with a new compound or new therapeutic, is it a disease state that's maybe sort of more predominant in certain jurisdictions? Where are you going to look for who's going to be buying the product? What companies are going to be selling in that area? So all this sort of market analysis of where you're going to end up focusing. And a patentability analysis. Obviously that's very important early on to look to see is, actually what you have, is it patentable? You have to meet 3 criteria. Does it have a use? Is it new? And is it non-obvious in light of what's been done before? And ownership, and we'll talk a little bit about all of these a bit later, but ownership is also very important. You don't want to spend all the money going down the patent process only to find that actually you don't own the IP and you've paid for it, but somebody else steps in and says they own it. And so what is involved in all of this? So you have to take a very proactive approach at the beginning to set up before you go into looking and filing patent applications to make sure that all the money you're going to invest is worthwhile and is being spent well. So what kind of things do you have to look at? You have to start off by gathering information at the beginning. Public disclosures. Have any public disclosures been made? Papers, posters at presentations, discussions with other company, researchers talking to researchers in another university because it's exciting and maybe they can collaborate, all of that information. Determine inventorship, and we'll discuss this in a minute, and understand the invention. So really look at the early stages of your research and where is it going? What really do you have possession of at that time? And where do you think you can get to with your research? Where is your research going? And then you're going to start off on the path of drafting the patent application and prosecuting it. So determining inventorship. The determination of inventorship and ownership is very, very important at the beginning. One of the reasons that inventorship is important is that if you have an incorrect inventorship on an issued patent and you've missed an inventor, you can actually be found for the patent to be invalid. So you don't want to go down the road to only find you miss somebody out, somebody challenges it and your patent's invalidated because of that. So who contributed to the subject matter? And it's the claims, the subject matter and the claims of the patent that are important for inventorship. So sometimes this can change during the life of the application. You might start off with 5 inventors, and as you're narrowed down through prosecution, you might have to narrow your claims, and it ends up that only one of them are the actual inventor associated with that subject matter. Sometimes having too many inventors on is not such a big problem. Missing an inventor off is. So always make sure you analyze. So at the beginning, when you're starting off down the patent road, look at everybody who's been involved and have they actually made a contribution to the subject matter of the claims. And then you want to look at who are these people, who are the inventors, and what is their relationship with the company or the institution that is now going to be filing the IP. Are they employees? Are they under contract? If they're under contract, who else do they work with? If they're at a research institution, do they have an agreement with the university? When was the invention created? Is this been something that's been going through the years and maybe there's been previous disclosures before, but then suddenly it's sort of become important and the focus has changed? Has there been prior disclosures that now affect it? Look at all of the history of when the research started. Ensure that you haven't omitted people that maybe have left part of a research group but were part of the initial invention, just they're not part of the research group now. Make sure you analyze all of that. You can have joint inventors on a patent application or a patent. That again, as I said, depends on the subject matter of the claims. And as I said, naming the correct inventors is very important. And then ownership, and all this sort of ties into who the inventors are. Obviously, for a company, there's increased value if the IP is owned by that single entity or by that company. If you own all of your IP, obviously then later on, if you're licensing out, you're not sharing part of the profits. This is all going to be your piece of the pie. Everything comes back to the company. Sometimes it's not always the case that you can do that. But again, look at the beginning before you're sort of going down the road of filing applications and then later assigning to entities. Who's part of this, and can you get some contracts in place before you start filing, before you go down this road, to really shore up that it is just your company that owns the IP rights. So you have to look at everything with the inventors: employment agreements, contracts. If they're employees of your company, is there an automatic clause in the employment contract that assigns the IP to the company? Have there been any third parties involved? If under contract, was there any IP discussions in the contract to say who it should be assigned to? Researchers at universities or at research institutions, do those institutions get a portion of the IP? Some universities have agreements in place where they get a percentage of any IP developed there, and until they assign back to the inventors, they still have a percent ownership there. And grants and funding. Has there been any grants being given to the research group or funding in the past that also had a clause about IP within it? Sometimes they don't, but sometimes they can be a bit more limiting if they've come from a big company outside providing the funding and the grant. Maybe they have an ownership in some of the IP. So you have to look at all the ownership issues around your patent applications and make sure you determine all this information up front, preferably before you file the patents, just so you know what you're dealing with along the lines, and to make sure that you have ownership in it. You don't want to go through paying to find that somebody else steps in and says, actually, we own 50% or 100% of this. And if you have joint ownership, then maybe you're looking to be able to share the actual costs of the patent process with somebody else, which is always a great thing. Be aware of potential bars to patenting. So public disclosures like publications, posters at conferences, which are things that are sort of quite prevalent in the life science area a lot of the times. These are sort of the things that you come up against because you're dealing sometimes with research that's coming out of universities, research institutions, where publications and posters will keep going on as research continues, and you might not be aware that maybe somebody's coming up for a big presentation next week at a conference, and that's going to start your clock ticking. In the US and Canada, you have a 1 year, what we call a grace period, before you file your application from public disclosure. So you do have some time there. In Europe, you're barred from filing an application once something has been publicly disclosed. So again, these are the things you want to look in at the beginning. Don't start investing in filing in the US, Canada, and Europe if you suddenly realize that it was disclosed 2 months ago, and so all your costs in Europe are not valid anymore because you're not going to have a valid patent because it was previously disclosed. Any of these actions, publications, public disclosure, will start the clock ticking in those jurisdictions where there are grace periods before filing. And if you are going to be discussing some of the research, some of the things that you have with third parties, look at doing it under confidentiality agreements, non-disclosure agreements, so that you can try to avoid the initial public disclosure prior to filing applications. File the patent application as early if you can. You have to be careful with this because obviously you don't want to rush at filing a patent application, realizing that maybe you're focused on the wrong thing, that you don't have enough support for what you've done just because you're about to disclose. So you have to really look at, okay, what is about to be disclosed? If there is a disclosure, can you put it under an NDA or confidentiality agreement so that it doesn't become a public disclosure? Or really do you need to try and get something filed? In the example of a conference, maybe you need to have something put on file before somebody goes to the conference and presents on what they're doing. And again, as a company going out to third parties to discuss what the company is doing, again, look at NDAs. So patentability analysis, should you spend the money? What are the things that you have to look at when you're actually filing an application to see if you actually have something that's patentable? So as I said, there are 3 criteria: a use, novelty, it has to be new, and inventive or non-obvious over what's already out there. And these are assessments that the examiners will take when they look at examining your application and look at prior art or prior publications, prior patent applications to see what else has already been done out there. This is where you can work with a patent agent to look to see, you know, what you're aware of that's already in the public domain and what you have to assess things like novelty and non-obviousness. Novelty is somewhat straightforward. Has it been done before? Non-obviousness is obviously a much more area that you have to sort of look into to analyze in detail to sort of say, okay, what's been done before, what's out there, and is it an obvious step to come to what my invention covers? What else should you look at when you're looking to see whether you patent something? Areas for investment in the research and development. Where is your R&D going? You know, you're going to find suddenly that actually you're switching tact. Maybe you've got small molecules or compounds for one disease state, but you're actually going to switch to a different disease state, and you're not pursuing these anymore. Is it really worth spending the money on pursuing patent applications on this if you're actually switching in your R&D focus at some point? So always assess sort of where are you going in research and where's your company wanting to take you. And look out to competing technologies. What else is out there? What's in the marketplace? Another analysis is patents that need to be circumvented. Are there issued patents out there that are actually going to cause you a problem? And is it something that you can work around, or are you going to need to license? And when you're looking at the patentability, are these also going to be a problem to be cited against your own applications? Or if you come out with some narrow claims, does it still prevent you from working your invention? Maybe then you don't want to pursue a patent application on your own thing if you're going to actually be stopped in the actual marketplace. And in all of this, you can then maybe look at possible collaborators, partners, or people that you could license to. So you may still choose to patent something even if you don't think you're going to get great protection, because maybe you could use it as a licensing tool. And maybe there are other players out there that you can look to collaborate with or partner with to share some of the costs of the patent process. Prior art searching. This is one area where sort of some people debate about whether to spend the money or not, because sort of searching, especially in very crowded fields, can be quite expensive. There's no duty to actually search for prior art, but anything that you do search for or find that has relevance to what you're filing an application for, you do have a duty to disclose it. In the US, there is a requirement to provide the Patent Office with any documents, references that you're aware of that might impact the patentability of what you're filing for. But one of the areas with searching is that it will provide you with an idea of what is out there. What are you going to have to sort of try to work around? Is it a very crowded field? Is this going to cause a problem for you getting broad protection in your patent applications and having something that's a very valuable tool? Are you going to end up being narrowed down because of what is already out there and published or patented? So you have to sort of consider all of these things. One of the areas to start off with, if you are looking to sort of just get a general idea, is look to see who the other researchers are in your field. If you have come from a research base, who are the other people in universities, other research institutions, Canada and worldwide? What are they doing? Do they have a lot of publications? You can search for inventor names in a lot of the online databases for the patent offices. Do a quick search to see, you know, do they have any pending applications or issued patents? It's one of the areas to start, to have a sort of look to assess the field. And competing companies, any other company names, look for them under owners in these databases just to see if there's anything that's showing. The caveat to that is applications are not published until 18 months after filing. So there is this sort of window where you won't be able to see what has been filed recently. However, if you're looking maybe in the actual publication databases and there's been some papers that have been done in the last year that are looking sort of quite new and maybe novel areas in that research, maybe sort of that might be a flag to show that they perhaps have also filed patent applications to cover that subject matter as well. So all these areas are areas that you can do some initial searching just to get a comfort on sort of what else is already out there, and if you still want to pursue going down the road, if you still think you're going to get some valuable protection for what you've done. And then you come to drafting the application. And you have to understand the invention both technically and in its commercial context. So you don't want to just draft some wishy-washy claims about what you're doing technically if they don't correspond to what you're going to be doing as a commercial end product. You want to ensure that claims that you have that hopefully end up issuing actually cover what you're doing in the commercial context and not just cover the great idea around what you're researching. And you want to have an enabling disclosure. This means that you not only cover the product that's in your application, but how you got to the product, how you made it if it's a compound, and if it's going to be a compound that's going to be used as a therapeutic, any studies that you've done to show that and to enforce its actual use. In vitro studies, animal model studies. In the ideal world, you'd have clinical data as well, but obviously in the life science area, that's not usually applicable because that's so far down the road that your application's filed years and years before then. But you want to ensure that you have enough support in there to show that you have possession of the invention and you've enabled it to show somebody else how to make and use it. Aim to providing claims in the application of varying scope. You don't want to just go in with a very broad claim but have no fallback positions. If the examiner comes at you and says, this is too broad, this is prior art out there, if you don't have anything to step back and say, okay, I'm not going to go for this breadth of claim, but I can go for the next level down, then you might not end up with a patent at all because you have no support for another variation. So put in claims of varying scope. You have a large compound claim, you may be going for a whole group of compounds with varying groups attached to it. Maybe there's just one compound that's of interest to you. You've got that in there as well, but you've gone for different breadths of groups on the compound, and I'll show you an example in a minute, to get varying levels. You might end up having claims to all these levels issued, or you might be narrowed down, but at least then you have the support for it. The claims of the issued patent define the enforceable scope of your right, so it's the issued claims that cover the scope of your invention and what you're doing. So it's not the claims that you had when you first filed the application, it's the ones that are issued. Those will provide you with the legal scope to exclude others from doing that subject matter. And draft different types of claims. Don't just go in for a product claim if maybe it is a product or a compound, but actually there's also going to be a medical use for it. It's going to be used in the treatment of something. Method of medical use claims are allowed in the US, they're not in Canada. We have use claims instead. The method of medical treatment in the US. So include those claims in there, but try not to reach for the stars. If you found a compound and you know that maybe it's going to work in one area or as a therapeutic for one disease state, try to avoid putting in a laundry list of 20 disease states that come to mind that may not be applicable. Well, the one thing you want to be careful of is trying to grab at everything in your first application, because if you end up being narrowed down there and later down the line find that actually it's quite novel, that it's actually applicable to something else, but you mentioned that as a one-liner in your first application, you'll be cited against yourself later on, and it might cause a problem. So don't try to stick to exactly what you're doing, but don't try to reach for the world. And an agent will help you analyze, what supporting data you have and what they believe that an examiner will allow you to get as a scope of claims using that data as support. It's becoming more and more tricky in some of the patent offices, US and particularly in Canada at the moment, to try to get a lot of broad coverage for things if you don't have the exact data to support it in the application. So you just want to be wary that you don't sort of have throwaway sentences in there or claims to things that you think it can do if you have no supporting data. You might not get your claim and it might cause you a problem later on if you suddenly find that you can pursue that application. And the other different sort of types of claims, medical device claims, actual product claims, whether it's a compound or a therapeutic, or maybe you actually have a sort of mechanical, like a stent or a pacemaker, product type claims, then method of medical use claims, a method of making something, and then use claims in Canada. And then obtaining the desired claim scope. What is the actual vendible product? Have you got support in that product? Do you have synthesis of compounds if you've made compounds in there to show that you've actually been able to make the compounds, and how? In vitro data, clinical trials. As I said, the clinical trials you very rarely get in a patent application, but the in vitro data is important to show that you have started going down the road of being able to prove that it may be applicable to a disease state. And what are the variants? When you sort of start off and maybe you do have a new peptide or a compound, or you've isolated a protein, take a look to sort of see, do you have time to research further, to look at variants from it? Don't just rush in to try and cover that one thing if you're maybe going to be doing some more research to expand upon the area, maybe find some more compounds. As I said, you want to sort of make sure that you don't cause yourself a problem if you're going to patent something later by an initial disclosure. And again, you also don't want to narrow yourself down too much by just going for specifically what you're doing if you can try to cover off variants, because that will also, if you have claims at the end that cover those, block competitors from coming into the marketplace and doing what you're trying to do or coming close to. Look at what your competitors are doing and sort of see, is there any way, and this sort of can apply later on down the road during the pendency of the application and the examination. If you suddenly find a competitor's come onto the marketplace doing something that's similar to what you're doing, can you amend your claims to cover what they're doing? If they don't have earlier applications filed, maybe you have a filing date that will end up that you can amend your claims to cover, providing you have support in your application, what they're doing, and then you can end up blocking them that way. So have a look to see sort of, what other people doing, and always keep an eye on that as you're looking through the prosecution of your files. And always come back to where is your niche area, what is your expertise in, and do you have claims to build on that to cover off a sort of exclusive area in the marketplace for you. So claim scope when you're looking at it as a whole. So there is your product. You want claims to cover your product. And always as you're going through prosecution, and this is one area to always be wary of, particularly for cost of pursuing applications, always come back to reviewing what is your product. The patent process is a long process. And what you do and we're interested in at the time of filing is not always where you're pursuing in 5 years' time. And you might still have applications pending at that time. In a lot of jurisdictions, examination is requested later. A lot of countries like Canada, it can take 3-4 years sometimes for a first examination report to come back. By that stage, you might be doing something quite different from where your focus was at the beginning. So always come back to make sure that the claims that you're pursuing actually cover your product. And then you have variants on it. So as I said, try to include a broader scope of claims that cover the variants around that. So for example, in a family of compounds, you might be very interested in one, you might have 1, 2, 3 lead compounds. You want to have claims to those compounds, but maybe include claims to a broader family around them and to variants. They may not be the ones that are specifically interesting to you at this time, but it'll certainly keep other people from sort of coming in and encroaching on your space. Competitors, look at what your competitors are doing. You want to try to cover off what they're doing too. And in that sense, you end up building a portfolio that covers all of these things. So you're not just covering what you're doing, which is quite a narrow piece of it, but you're building a much better, and this gives you much, much better value as an IP portfolio for people coming to invest in you. If you're just covering your product, and outside of that are all these variants and competitors, it's not that interesting for an outside investor to come along because they know there are going to be a lot of players in this field and they're going to be sharing the market with other people. If you have a much bigger portfolio covering that and you've got your niche area in the market, you've captured that marketplace, it's a much better company to invest in. So this is just an example of the type of different coverage, for example, in compounds that you might be seeking. The top compound there is a very, very broad scope of compounds that covers, thousands potentially compounds when you have all of your requirements for your Y, your X, your W groups. And then you have 2 different levels of narrowing. Maybe at the bottom there, these are the compounds that you have. Maybe you've got examples in your application, you've got data behind them, but you don't actually want to be narrowed down to this. You want to try to get that top scope, because if you can get a claim with that, you're obviously going to keep out a lot of competitors and a lot of people coming in. So you want to have varying levels. So here you've narrowed it down. Maybe at the beginning your A group is a heterocyclic ring with 1 or more heteroatoms in it. You come down to a benzene ring, and then you come down to different narrowing scopes of all of these groups. So it's sort of these fallback positions where you go in with your claims to say, okay, I really definitely want coverage for the bottom one because my compound falls into that, but I also want to try to get broader coverage to keep other people out. So obtaining your desired claim scope, filing of a full and complete disclosure. So this is what I said earlier about making sure that you've supported what you're aiming to patent in your claims, what you're aiming for support of your claim subject matter. You can only get protection for what you've done and shown in the description, and what you can soundly predict based on what you've done. Now that's changing slightly in Canada with some of the recent case law that comes out that says sound prediction is also a tougher thing to argue, and you need to include data in there to show what you based your sound prediction on, but case law can change. So, you still want to look at what you have done, what you've got in your description, and see if that's something that you are going to depend on. Whenever you're drafting patent applications, there's always new case law that comes out in different jurisdictions, maybe to argue against some type of scope of claims. One year you can do it, maybe the next year you can't. You should always be aware of that, but doesn't necessarily mean you can't include those claims in your application. Once you get through the examination phase, at that point it's the time to argue to see what the most recent case law is. So don't be hindered by seeing a case law or hearing somebody saying, oh, you can't get those types of claims, unless it's statutory non-patentable subject matter, and then it's likely you're not going to get it. And case law can vary depending on where the courts are, what level the decision has come out at. So always be aware of these things, but this is something that the agent that's working with you can help you with and decide the types of claims you go for. Your disclosure of all your contemplations of the invention, so this comes to different variants, ensure that you've got disclosures for all of those, the different scopes. And demonstration of utility through test results wherever possible. We understand in the life science area that it's not always possible to have the data on everything, and there is that fine line between having to get something filed and how much research is needed to support everything in the application. A lot of the times there's way too many years of research to have to put everything to support absolutely everything in there, but have you got some data to support a sort of a large group, and then can you argue to show that that data is predictive for your other compounds or therapeutics that you're looking for. And you can also sometimes look to see, maybe if you're doing a provisional filing, and we'll discuss that in a minute, an early stage filing where maybe you're filing in another year's time, is there information or research that you're doing within that 1 year that you can then add. And if you're really intent on trying to get patent protection for the scope of the claims that you first file, can you actually gear some research towards providing more data to support what you're trying to seek patent protection for. A lack of a full disclosure can lead to unduly narrow claims and possible invalidity of the patent. If you don't have the data in there to support the claims, you're going to be narrowed down to exactly what you have. If you have one example of a compound and you're trying to get a really broad family, but you've just got one compound, one synthesis, and nothing else, the examiner might end up narrowing you down to just that one compound. So then you look at where your first filings are going to be and where you can save money in going through the actual filing process. Filing fees, translations in non-English speaking countries, all of these things are where sort of the money starts to trickle away. Typically Canadians tend to file first in the US, and a lot of that for a couple of reasons. One is that the US have what we call a US provisional application, and another is that a lot of investors show preference for people having a US filing. So that's sort of the two main reasons. A provisional application traditionally was used as sort of what people called a quick and dirty filing. When you were going to actually have a disclosure, you could file a quick provisional, it would buy you some time. You can file a provisional application in the US, and then 12 months later you make your regular filings, you convert your provisional into a regular US, and you also have to file in your other jurisdictions around the world, claiming priority to that US provisional if you want to keep that US provisional filing date. More and more now, it's so very important to make sure that the specification and the information in the provisional is very, very complete. A lot of the times people would sort of file a provisional just on a general idea. Now, if you don't have all of the supporting data for what you're ending up, for the claims you're pursuing, you won't be able to come back to the actual filing date of that provisional as support. And if you end up adding information in your regular filings that you do in 1 year, maybe you have more data, maybe you finally got some synthesis for your compounds. If you didn't have that in your provisional filing, you might not be able to claim back to that filing date, and any intervening art that is issued, any publications that have been made, can now be cited against you. So if you're going to go down the provisional route, make sure that you put as much information in there as possible. There are times when provisionals need to be filed because somebody realizes a disclosure is going to be made tomorrow, a paper is going to be published, and you have no other choice but to sort of get into the office and try to file something to get that date. But try to spend as much time as you can in that 24-hour period to include as much information as you can. and then revisit straight away afterwards, should you be doing another filing again, because you can claim priority back to more than one application to start getting everything on file. So there are many different options for filing, and the strategies behind them can vary from wanting to straight away go out into the marketplace because you have maybe a medical device, you've already decided the end prototype, and you want to come in as a commercial product, and you want to get patents issued everywhere to protect it. Or in a situation, the opposite end, where you've got a lot of further research to do, that you're not actually near a commercial product, so you don't want to have patents issuing straight away because you're actually not sure what you need coverage for. So there are different strategies you can take. You can always go straight into the countries that are interesting to you and file in those countries, and that's the case where you want to sort of expedite to get to an issued patent. Obviously there's going to be filing fees associated with that, translation fees in non-English speaking countries. One of the other options is what we call PCT application, which is an international application. It does not issue to an international patent. There is no such thing as an international patent. It is an application that you file that the countries that are part of the PCT corporation, and there are many, 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 most of the interesting countries that people want to file in are covered in the PCT application. You file one application, you pay the initial fees. They are a bit higher than some of the other filing fees, but you do get an examination report. 30 months from the filing date of either the PCT, or if it claims priority, to the original filing date, you then make your selection for going into the different jurisdictions. So you've delayed time in which you have to pay for the patent filing fees and examination fees in the individual countries. And in the meantime, you've got a search report and a written opinion or a patentability opinion from the office where they've done a search to see what else is out there, and they've given you an opinion on whether they think your claims and the subject matter in your claims are novel and non-obvious. So it's one of the ways to buy some time. Maybe you need to do more research. You're not sure where your end product is. You don't want to actually go into the countries to secure the rights yet. Maybe you're looking for more investors. You need somebody else to help pay some of the costs of the patents. So the PCT is one route that you can delay some of those costs. You are going to have to pay them eventually, but you can delay them, and you can also get this examination report. Some other countries also do advanced examination. Canada has an advanced examination system. Europe has what you call the PACE system, which is advanced examination. So some of those you can look at as well. The advantage of the PCT is you sort of held your place for filing in all of these other countries that you then do at the 30 months. Whereas if you're filing first in Europe, you still have to file everywhere else within 12 months to be able to claim back to that priority date. But these are all things that you should think about when you're first looking at filing your applications. Is, are you needing to buy some time, or are you needing to expedite prosecution? And you should then talk to your agent about, what are your options at that point to be able to do that. European application, again, if you're looking at just Europe as an area that you want to seek patent protection, you can file a European application, and it covers the EU member countries. Once the European patent issues, you then do have to validate in the individual countries. You are going to have to pay maintenance fees in those countries, but you've had one examination report through the European process. So prosecution, what kind of things can you do in prosecution to look to sort of be a bit more cost effective in where you're spending your money and ensuring that you end up with patents that cover the product and what you want to end up doing commercially? So a well-prepared specification and claims can make prosecution cleaner, which can reduce costs. If you're in a situation when you've done that really quick and dirty filing of a provisional, a year later you convert it and you don't make any amendments to it, you just file it as is, as it was a year ago, you can suddenly come up with a situation where you're in examination, you realize that actually it didn't cover what you're now doing. You actually don't have support for what you're now doing because you didn't revisit, you didn't do your different layers of your claims, your different scope. And now during examination, you're having to do a lot of cleanup to try to argue that you should get coverage for your claims. Whereas at the beginning, if you'd taken some time and had those fallback positions, it would have been an easy argument to make. You show where you've got that support in your disclosure, and then you proceed forward with your claims. So always at the beginning, a thought out plan when you're first drafting that application, and having the support in there makes it much easier during prosecution to be able to end up with the claim scope that you would like. Be aware of file wrapper estoppel in the US. That's just an issue where you sort of be careful what you put on the record, be careful what you talk about. Sometimes this relates to prior art as well. Don't just make sweeping comments about prior art in your application in the background, particularly if maybe that prior art could be construed another way. You don't want to be seen as maybe not disclosing what you should have done or trying to persuade the examiner of an opposite situation. So always be careful what you're arguing with the examiners as well. And this can also end up changing the scope of your claims too. And the duty of candor in the US is ongoing, so always you must provide the US Patent Office as you're going through with any references, patents, publications that have some or may have some influence on whether the patent that you're seeking protection for, the subject matter, issues to claims. If there's a relevance there to your subject matter you're seeking, you need to provide the US with those references. So when you're looking at seeking protection in other jurisdictions, what type of thing should you look at? What countries do you choose? Do you just go for what everybody else goes for, or do you really have to sort of take a strategic look? And the answer is you really need to assess where your market's going to be and where you're going to be practicing your invention. Not only the end product, but maybe a manufacturing step. Where is it going to be manufactured at the end of the day? The market for the product, your patent is 20 years from time of filing. And specifically in the life science area, unless you're looking at actual sort of physical medical device, therapeutics, compounds, can take medical treatment, obviously take a lot longer. You have to go through clinical trials. So you have to sort of look to where your market is at the end of the day. But sometimes make decisions early about where you file because you only have a limited time to seek patent protection in those countries. So one of these things as well is looking to future markets. Where are there growing economies? China, for example, maybe 10, 15 years ago, people were not looking to file applications in China. Well, there's a large population, increasing disposable income. So maybe that is a place that you want to look to. Maybe choose China instead of somewhere like Japan, because maybe the potential end market is a lot bigger and it's going to provide you with a lot more value for that IP later on. Where is the product manufactured? Specifically in a case of a therapeutic or even a medical device, where is it going to be manufactured? Is it going to be manufactured in China if it's an actual medical device? Is it cheaper manufacturing there? Again, do you want to have protection there to keep out other people or other people that choose to use that market to make a similar device? Strategic locations for other competitors as well. Where are they located? Where will they be manufacturing their drugs, their medical devices, their compounds if they're trying to come on as a competing market? Where are your competitors? Where's the research occurring? Where are the people heavily working in this research area? Maybe is it the States, maybe is it somewhere in Europe? And what jurisdictions are patent friendly? Which areas are the countries now actually policing people who are infringing their patents? There isn't much worth in a patent that issues, but then when people come along, they can easily infringe and there are no tools to go after them, or the courts are not patent friendly. So you want to also look to sort of those areas as well, especially in some of these emerging markets. So this is just sort of one of the things to think about when you're thinking of countries. There's your consumer markets, the US, Europe, Canada, Japan, China. Again, where is there high population and disposable income, quality of living? Canada, you do have disposable income, quality of living, but there's not a high population. Obviously, if you're a Canadian company, you want to seek protection for Canadian patents on your own doorstep, but you also look to places like the US and Europe, specifically if you're looking at a drug or an end-use therapeutic. Where are the people, where is the mass population, and where are people that are going to be able to afford the product as well? Might just have high population, but if people can't afford to pay for it, and if there's no government that's willing to pay, for example, medical compounds, drugs, then maybe that's not the market for you. The producer's market, who's manufacturing it? As like I said, low-cost manufacturing in China, maybe that's one area that you look to seek protection for. And where are your competitors? Where are there areas, for example, advanced education, natural resources? Where could people be looking to develop similar and competing technologies? And then enforcement. China didn't have a great history of actually enforcing the rights of patents, but a lot more recently in the last decade, you're starting to see a lot more government backing relating to enforcement of patent rights. So maybe now that's a market where you choose to look to focus. And then post-filing considerations. So not only have you got to do the assessment up front of, do you own this IP? What type of protection can you get? Is this value for the company? Am I going to protect what my end commercial product is going to be? You also want to now consider, as you go through the prosecution of all your applications, that you maintain control over the area that you're focusing on and that it aligns with your own R&D in the company and the development of your products. So always when you're going through the patent process, when you come up across an examination, when you come up at maybe another filing decision or payment even of a fee at some point, is that patent still relevant to what you're doing? Is that application still focused on where you are? And if you've changed track, is it worth keeping the actual application? Maybe you can use it to license to a competing company out there, to a competitor that works in that space, even if it's not specifically relevant to what you're doing anymore. Is there value in that? If there's no value in that, then why are you still paying for all the fees for it if you've switched tack to maybe you've got two separate portfolios running and maybe you're throwing money on one where it should be focused on another? So always keep in mind what your business plan is, where your research is going, and what you're actually doing. And then freedom to operate. One of the issues of, do you actually have the ability to practice your end invention? What you searched at the beginning to see what was out in the marketplace, what was out in the patent field, and you thought you had freedom to operate. As you've developed that product, do you still have it? And freedom to operate is one of the things that investors will always look at to say, not only do you have something that's patentable and can you get good protection for it, but are you actually also able to operate? Or are you going to have to license from somebody? Because that will also change their perspective on how valuable your own IP is, but also how valuable your product is. If you're going to have to go out and license to somebody else, maybe it's not an area that's as of interest to them. This is just a quick slide to show you your different timelines you're dealing with. After your first filed application, you have 12 months in which to file any other application where you want to claim priority to that first filed application and get that first filing date. Then you have 18 months from the first filing to publication. And then if you filed a PCT, you have up to 30 months from that first filed application to decide what countries to go into. And as I said before, I think that the delay in time for something like a PCT allows for maybe possible funding, looking at outside sources, potential partnerships, maybe research and test results, maybe to see if you actually really want to pursue this application. Maybe you're on the edge of finding out that maybe the compound of interest to you actually isn't that interesting, and also partnering and selling. And then maneuverability, to keep pending applications alive if you can, if you are not at the stage where you've actually got a commercial product. So once you've got your patent applications filed, there are sort of two directions you can take. The one where you've actually got a commercial product, you're coming into the marketplace, and you want to fast track your patents to get them in, your patent applications, to get them to issued patents, so you have something concrete to protect your own and to be able to go after potential infringers. Then there's the other side of it where maybe you're still working on your research, you're still developing your product, and actually sort of having issued patents, you know, is a bit maybe nerve-wracking for you because you're not sure if that's actually going to cover what you're going to end up doing. When you have pending applications, it always allows you for the flexibility to be able to change your claims, amend them, providing you have support in your application for what you want to amend them to change the scope as you go along. So there are different strategies you can take in jurisdictions to ensure that you have an application pending that allows you to do that. It will give you the ability to amend the claim scope. Also, if you have pending applications, third-party investors, if they're maybe looking to buy the company or to invest, and particularly usually if there's a buyout, maybe if they're going to change the research a little bit, maybe the applications will allow them to change claim scope to come in line with something they're looking for, so it might be advantageous too. It doesn't mean you can't necessarily have some issued patents as well. And I'll describe one situation in the US coming up.
Is a pending application just one that has not yet been granted?
Yeah, so while an application is going through examination, it's a pending application. Once it's been granted, it's an issued patent. So patent application pending, issued patent. So in the US, there's a particularly unique thing that have in their practice, in their patents, it's called continuation practice. And this is where you can have an application be examined, you can narrow the claim scope, or the examiner might be narrowing a claim scope or ask you to take some of your claims out. You could end up with an issued US patent to some narrower claim scope, but you can file a continuation application before that first one issues that allows you to continue to pursue the broader claim scope. They're all going to be part of the same family, they're all going to have the same patent term, but it keeps you sort of going through the examination process and allows you to get sort of different breadth of claims. So it might be that an examiner comes back to you straight away and says, no, you can't go for this sort of broad claim scope. You know, these claims, these narrow claims at some point is what I'm going to allow you. You might think it's advantageous at that point maybe to get an issued patent on that, but file a continuation so you can continue to argue why you should have broader claim scope, but you've also got an issued patent in your hand. Maybe those claims cover exactly what you do, so you're covering one aspect, and now you're going to try to seek broader protection to keep other people away. So that's one of the ways and considerations to take in the US. There are other sort of unique parts of US strategy, and all these things you should always be talking about with your agent as you're going through to sort of say, you know, I need more time, I'm not sure if I'm wanting this issue straight away, what other strategies can we do, and weigh up the cost to see if, you know, the cost of doing it is going to provide you with the right value for it. Continuation in part applications in the US, this is unique to US practice. When you've maybe got an improvement on something, you're adding some subject matter to an application, you can still file a continuation in part that goes back to cover the broader subject matter that overlaps with the previously filed application and adds in your improvement. So the improvement will get your new date, but maybe the broader subject matter goes back to an earlier date. In Canada, there is no continuation practice. You can have voluntary amendments and voluntary divisional applications, and forced divisional applications. This is where an examiner will come to you in a similar practice in other jurisdictions, and they'll say you've got more than one invention in your application and divide it out. This is really, you should only sort of follow the examiner when the examiner comes forward to you and says, you know, you've got more than one invention, you can either argue it or you can separate them out. Avoid trying to do that yourself in deciding that you should separate them out. Because you can end up with a double patenting objection. So always let the examiner come to you to say, you know, these should be separated into different applications. And this can be a situation where maybe you have a compound claims and method of medical treatment claims, and the examiner may decide that, you know, your compound is going to stay in one, your method of medical treatment is going to be put into another application. They want to do too many searches, it's burdensome for them. So these are situations. One of the advantages of the Canadian office, what can be seen as an advantage or not an advantage, there's a 5-year delay for requesting examination that you can do. You can request examination straight away, or you can wait 5 years. If you don't request examination by 5 years, your application will be abandoned. You can reinstate 1 year after that. But this may be a delay tactic for you. Again, if you're not sure where you're going commercially, you can use this to not pay the fees for examination. You're just paying maintenance fees and you're just waiting. And it's not a huge cost at that point, you're not investing greatly. This says a 2-year backlog at the Patent Office. That might be being a bit optimistic. Sometimes it can be sort of 2 to 4 years depending on the field that you're in. Some of the life science biotech areas, it is taking quite a bit of time to get an examination report once the request for examination has been made. So always be aware of that. You don't want to sort of suddenly realize you need an issued patent and then realize that you're still going to have to wait after your examination a couple of years to get an examination report, although you can get expedited examination.
To clarify, if there's that much backlog and you file with PCT, you've got 30 months, how does that affect your PCT applications? You have to go ahead and file there. How does that contribute?
You mean the backlog with examination? It doesn't, the PCT office is much faster at giving you your examination report. So you'll still have your examination report at your PCT stage. You won't enter Canada until you're 30 months. So at 30 months, you could go in, if you've had a positive report at the PCT stage, right at filing in Canada, you know, if you want to pursue that, you can file a request for examination straight away or an expedited if you want something issued. If you don't, then you're filing your application and you can wait another 5 years. So, you know, you still have that requirement. It's 5 years from the filing date, though, not when you enter the national phase, from your PCT filing date. So it's not that you've added another 5 years at the end of your national phase entry date.
So the PCT isn't going to say, sorry, you're out because Canada's so slow.
In what sense?
I was just wondering the timeline. So you filed for PCT, and now you have to say which countries you're going to
At the 30-month stage, yeah.
Right, and Canada is still looking at your patent.
Well, they won't have looked at it until you enter the national phase. So you file in the PCT, and it's the PCT receiving office, wherever you filed, that does the examination for you. And you get your report, and then at 30 months you go into individual countries. You still have to go through examination in those countries. And they will not start examining it, even though the PCT covers these other countries. Examination will not start in any of them until you've officially filed national phase entry in that country. So at that point, now you're into the Canadian Patent Office and all your deadlines start ticking. So the exam you'll have to do, request it 5 years from your PCT filing date, because that will be your Canadian filing date. So yeah, none of the national offices will start examining your PCT application until you've entered the national phase. Mainly because you don't necessarily are going to proceed with filing in those countries. You might just choose at the end of the PCT, depending on your search report, to just do the US and Europe. So the countries will not start looking at that until you've officially got that national phase entry date. In some jurisdictions as well, once you've got an issued patent, there are ways to go back and amend the issued claims. Usually this is in a situation maybe where you're heading into some litigation and you want to sort of do some tweaking, unless you've seen that you've maybe, you know, there's something that you want to change in the claims, are they too broad or they're too narrow. Some countries will allow for reissues, amendments after allowance, some countries not. So you have to look to see, and there are very, very strict criteria for reasons to be able to do that. And then improvements. You should always be aware as you're proceeding through your research to look to improvements. You know, if you haven't gone exceedingly broad in your initial application, then maybe as you go along and you find that there's things that you need to tweak, you're changing you know, if you found a new compound or a new subgroup of the compounds that you looked at before that are improvements over the ones that you filed applications for, a new way, a new coating for a stent that you filed an application on before, you can proceed obviously to file for patent protection on those things, provided that they're new and non-obvious. The one thing that you should always be aware of is if your parent application has published, it can be cited against you. So if you're looking at improvements and it's sort of pre the 18-month publication of your first application, you maybe want to sort of think about filing that before your parent case or your first case is published, to ensure that you're not actually arguing over yourself. You want to be very careful about when you're making claims in the examination stage of what is obvious and what is not obvious. So if you're wanting to actually also claim priority back to your first filing date, you have to do that within 12 months. So always be aware as your research changes, if you've come up with a new improvement or a different way of doing something, have a look back at your initial filing. Do you think you're covered? And if not, should that now be the subject matter of a further filing? And always look at the timelines and sort of what issues could arise because of that. As it says, if possible, file improvements before the parent publishes. That's not always possible. Maybe it's 3 years later that you do some research and you realize that there's a change in the focus. But always bear these things in mind. And freedom to operate. As I said at the beginning, patents don't necessarily grant you the right to sell your own product without potentially infringing another patent. So you always want to look at these, particularly when you're looking at outside investors coming to invest in the company. You want to be able to tell them whether, you know, have you done some searching, you know, do you have the right to go out into the marketplace. Sometimes people who are investing in the company will do those searches for you. Sometimes they'll want to know if initially you have done that up front. And again, a great place to start with the searching is competitors that you know, whether they're other companies or other researchers. Freedom to operate opinions are jurisdictional. So if you're looking at, do you have the freedom to practice your invention in Canada and the US and in Europe, if you're actually wanting an official opinion on that, you have to look in each of those jurisdictions. A patentability opinion, whether something is patentable or not, is based on references published worldwide. But freedom to operate is based on what patents have issued in those countries. As I said, patents are jurisdictional. Somebody might have filed in the US but didn't file in Europe. Maybe that means you have freedom to operate in Europe but not in the US. So you always have to look jurisdiction-based. And so just some final comments really when you're going through assessing sort of the value and looking to invest in IP. It is an expensive process, patenting. No one can tell you. It is certainly expensive, filing fees, government fees, the time it takes, drafting applications, prosecuting them, examining them. So you always want to come back to really review, you know, what you're doing as a company, where are you heading, have you changed your focus in your research, and always come back to looking to cross-reference your patent application and your portfolio. Does it cover what you're doing? And if you see new competitors coming onto the marketplace, assessing, do your patents and applications cover what they're doing, and if they don't, is there a way to amend your claims to be able to cover and to try to keep them out, providing that they themselves don't have some earlier patents that they filed too. So always monitor your research, monitor where you're going, and really take a good look when you're investing, both in filing fees and looking at investing in other jurisdictions. Is this valuable to your company? What is your end product, your commercial product? Where are you going to be practicing this? And do you have the coverage for that? Have you gone beyond it? Can you scale back? Or have you not gone far enough? An investment made early in IP can save you money and time. So do spend the time, if not the money, up front to just really make sure that you're filing a complete application to assess what you need to go in there to support the claims that you want to try to have issued, to make sure that the value that you've put in is worthwhile at the end game. And any questions?